Now I am extremely pleased to introduce Professor Agnieszka McPeak. She is the Associate Professor and Director for their Center of Law, Ethics, and Commerce at Gonzaga University School of Law, who will be moderating our Legal Perspectives panel. We also have Stephanie Verjoya, a recent graduate from the University of Washington Law School, and she will be moderating the chat for questions. So please know that when you put your questions in the chat, she will organize those and filter those to our panel on your behalf. With that, I am very pleased to welcome Professor McPeak.
All right, thank you so much, Dr. Hoffman. So we will now be transitioning into our Legal Perspectives panel. I'd like to actually begin by introducing myself and a few housekeeping matters. So this is Legal Perspectives panel, our first full panel for the day. I'm Agnieszka McPeak. I'm a faculty member here at Gonzaga Law, and I direct the Center for Law, Ethics, and Commerce, which is very happy to co-sponsor this event with University of Washington Center for Leadership and Athletics and the Knight Commission on Intercollegiate Athletics. So I'll serve as moderator today as we discuss the legal landscape of college sports, particularly issues surrounding NIL rights and compensation. We do have an outstanding lineup for you today of legal experts, and I'll introduce them in a moment. As mentioned previously, this is a webinar Zoom that is being recorded. Only panelists are visible and able to unmute. So for audience questions, please use the Q&A function or the chat box. We prefer the Q&A function, and feel free to type your questions throughout the panel because we will monitor and answer as we go. This panel will go till around 11 a.m. and then we'll take a short break. So now I would like to go ahead and introduce our panelists for today. We have four distinguished panelists. I'll begin with Professor Deborah Brake, who is an Associate Dean for Research and Faculty Development at John E. Murray, and the John E. Murray Faculty Scholar and Professor of Law at the University of Pittsburgh School of Law, where she teaches constitutional law, employment discrimination, and gender and the law. She is a nationally recognized scholar on gender equality in the law with expertise in Title IX and athletics, sexual harassment and sexual violence, employment discrimination, pregnancy discrimination, and retaliation. Next up, we have Professor Gabe Feldman, who is the Cher Garner Professor of Sports Law and the Paul and Abram B. Barron Professor of Law at Tulane Law School. He is also the director of the Tulane Sports Law Program, co-founder and co-director of the Tulane Center for Sport, and Tulane University's Associate Provost for NCAA Compliance. He is a prolific blogger, podcaster, author, and editor, focusing on the intersection of antitrust, labor, intellectual property law, and the sports industry. He also serves on numerous boards and committees and makes frequent media appearances, including as an on-air legal analyst on the NFL Network. He teaches antitrust, sports law, negotiation and mediation, and contracts. We also have Professor Michael McCann, who we just had the pleasure of hearing from as our keynote speaker. He is the founding director of the Sports and Entertainment Law Institute at the University of New Hampshire Franklin Pierce School of Law. He is an award-winning journalist, best-selling author, and he teaches various sports law courses, including amateur sports law and name, image, likeness in sport. Last but not least, we have Professor Meg Penrose, who is a professor of law at Texas A&M School of Law. She writes in the areas of gender discrimination, Supreme Court jurisprudence, constitutional rights, and free speech, including college athletes' First Amendment rights on social media. Her courses include constitutional law, First Amendment law, a Supreme Court seminar, and Title IX. And she is a former Division I scholarship athlete in women's basketball who left college without debt. Meg's extended family has 3 generations of NCAA athletes, including most recently a Division I national champion. Her family's experience influences her approach, and family members include a Division I football player, Division I men's and women's basketball players, Division I volleyball, and Division I gymnastics. At this point, Stephanie will paste into our chat box a link to the full agenda for this event, which does have bio links if you want to read any more about our panelists. But now we will actually begin our panel discussion. And the first topic we will be discussing in this panel will actually be the current NIL landscape and its implications. So I actually would like to begin by directing a question towards Professor Feldman. If you could walk us through sort of the current landscape of NCAA compensation and NIL restrictions, and perhaps we can also discuss some of the justifications for and against the current rules.
Sure. Thank you, Professor McPeak, and thank you for having me. And it's good to see fellow panelists. And it's always fun. Professor McPeak is a Tulane Law alum, although she was not one of my students. It's good to see a familiar face doing well in academia. So the current landscape of NCAA compensation, NIL restrictions, I'm going to try to be as broad and succinct as possible so we can dig into the implications of the rules and the rule changes. But the general rule that the NCAA has had in place for over a century is what is commonly referred to as amateurism. And the amateurism model says that college athletes cannot be compensated based on their athletic ability. And what that has traditionally meant is that they cannot be paid to play their sport. But what it also has meant is they cannot be paid for the use of their name, image, and likeness if the value in their name, image, and likeness comes from the fact that they play sports. So if they wanted to do an endorsement ad, an endorsement with Nike or apparel company, if they wanted to have a YouTube channel that showed off their athletic ability, they were not allowed to do that. If they wanted to promote the fact that they were giving lessons in their sport by using their name, image, and likeness, they could not do that because that would be receiving compensation based on their athletic ability. The one broad exception to that has been the athletic scholarship. Very early on, college athletes were not allowed to receive athletic scholarships because it violated the notion of amateurism because it was compensation based on your athletic ability. Literally, you're getting money because you are good at sports and we're going to pay for your education if you come here. That obviously has changed. So now the rules primarily we think about are around these extra benefits. And again, those primary extra benefits are being paid to play, being paid to come to a particular school, being paid to transfer to a school, or being paid for name, image, and likeness. The justification for those rules historically has been a number of things, but from an antitrust perspective, the primary justification is that the NCAA is trying to distinguish college sports from pro sports. And the reason they try to distinguish that is so that college sports will be more popular. So consumers will have a product they enjoy. So it'll provide differentiation in the market so people can choose to watch professional sports where the athletes are paid to play, or they can watch college sports where the athletes are not paid to play. And if we start paying the athletes in college, they just become maybe poorly paid professionals, and consumers lose that choice. They lose that ability to watch and consume a different product. Other justifications have included that if we pay athletes at the college level, it'll interfere with their academic pursuits, it'll interfere with their education, it will corrupt the academic process, it will lead to a race to the bottom where athletes and schools are just chasing money instead of chasing education, and a whole host of other, I would say, vaguely paternalistic or maternalistic reasons. But the primary antitrust justification, and the justification that has carried the day since the Supreme Court's decision in Board of Regents in 1984, all the way up to essentially today, is that if athletes are paid beyond their educational expenses or beyond their cost of education, then it destroys the line of demarcation between pro and college sports. The justification against the current rules, very quickly, is why are we limiting the economic rights and civil rights of athletes in the name of providing a product that we may like a little bit more? There's no other industry that allows it to define itself by the restrictions on labor. We don't let Apple and Google and Microsoft come together and say, hey, we know we have these professional computers, but let's create these amateur computers that are made by unpaid engineers, because consumers might want to have amateur computers. We let an antitrust law lets competition decide what consumers want, what the optimal outcome is. But the courts have made an exception for college sports on the notion that college sports are different. And they're different for a variety of reasons, but one of the reasons is because there are a bunch of schools that come together to create a product they couldn't create on their own. And two, they're creating this not only sports product, but this amateur sports product. And the only way they can do that is if they all agree not to pay the athletes. Because if any of the schools were allowed to pay the athletes, then competition would kick in, and all of a sudden all the schools would be pressured to pay the athletes. And so this is one of those rare cases where the courts have said, competition would be bad because competition would lead to pay to the athletes, and pay to the athletes would destroy this great special product we have. So that's the arguments for and against in a nutshell. I would normally spend a semester on that, but I tried to cut that down to 4 minutes.
Excellent. I welcome any other panelists to contribute if you have any thoughts or additional comments here.
It was perfect.
It was you had a whole semester condensed in 5 minutes. Excellent. So the next question, I'll actually begin with Professor Penrose. How should the various indirect compensation items be evaluated when considering NIL rights?
Yeah, so this is one of those few instances, I think in the next couple of days, we're going to look at the status quo, right? This short section here. And I want to thank Professor McPeak, both universities, and my fellow panelists for bringing this discussion to the forefront, because I think it is really critically important. It feels like we're at a moment with the NCAA where this is a giant Jenga game, right? That we're just waiting for the next piece to be pulled out and to see whether the structure holds. But to admit that there's a problem doesn't necessarily mean that we should adopt every offered solution. So right now, when we think of the status quo, what do college athletes receive? Well, hopefully they receive an education. The NCAA's most recent statistics showed that college athletes are graduating in a 6-year period at about 90%, whereas non-athletes are graduating at about 70%. Well, why is that true? Well, college athletes have specialized tutors, specialized computer labs. Most college athletes, and I'm speaking generally towards the Division I level, specialized lounge areas, study halls that are just for athletes, the tutors that are just for athletes. You have advisors that are just for athletes. Because in the college world, these athletes are highly regulated. Their time is highly, highly focused, and usually not set by themselves. They're not like a singer. They're not like an actor. Their freedom of movement is somewhat restriction because they're participating in athletics. They get an inordinate amount of college gear, right? Athletic only team gear, shoes, windbreakers, coats, shorts, just an unbelievable amount of clothing that can only be accessed by the athletes. They have access to the best sports doctors that exist in nearly every state. They have constant training, strength training. They're required to go in for taping and cold tubs, and they have access to facilities on campus that no other college student, no faculty member, no one else has access to. In these auditoriums or in these football facilities, there are areas that are reserved for college athletes. And right now, that is what is the recruiting tool that universities use. Ole Miss a few years ago redid its basketball program, and it was like a moon. It was an identical mirror situation where the women's facilities were 100% identical to the men. Huge student lounge with access to video games. Now, because of the O'Bannon litigation, what we've seen is advancement and students getting more and more non or indirect compensation. What does that mean? College athletes should not be going hungry. They have unlimited snacks, access to unlimited food. In these study lounge areas, in their locker rooms, you have healthy food available. What else do students get? Travel, unbelievable travel. They're going to locations that a lot of other college students never go to. Men's basketball teams, when we look at men's basketball and football and women's basketball, which is generally driving this conversation, you're looking at trips to Hawaii, you're looking at trips to Jamaica, at resorts that most people that are in college could never afford. You're looking at international trips. These athletes can go during the summer to Italy for a week. You're looking at healthcare, free prescriptions, free eye care. As I said, access to the best surgeons or physicians if you need them, sports psychologists, general psychologists. They're getting dedicated seminars already, resume building, cooking class, building your brand on social media. So if you're a college athlete at a Division I school, particularly one of the Power 5 conferences, you're getting an experience at college that no other college student can pay for or gain access to. So as the NCAA is looking at this, I think there are a lot of individuals evaluating that indirect compensation. I don't think that makes up for name, image, and likeness, but it's also something we shouldn't take entirely out of the equation.
Anyone else have anything to contribute about indirect compensation in the current model?
It was perfect.
I know each answer is so perfect. We don't have any tension on the panel yet. So I will then move on actually to the next question, which I will direct to Professor Brake. What are the Title IX implications for an NIL rights system?
Good morning, everyone. And I should start off with my answer by saying it's not going to be perfect. So I hate to break the string here, but I'm going to start with a big dose of humility and say that if I'm honest, I'm not sure anyone knows what the Title IX implications are going to be. It's really quite complex, and we really are. I mean, we're in some new territory, although what I want to start out in my answer by saying is that it's new in the specific application, but it is a very old tension we have going on here that we've had from the very beginning with Title IX. And that is the tension between Title IX's model of sports, which is participatory and focusing on the educational benefit and the commitment to make that educational benefit equal, as applied to a model of sport that has increasingly become commercialized and not so much about that educational benefit as the market-driven model that has overtaken college sports increasingly in the last decades. Now, that tension, frankly, has been with us from the very beginning. From the moment it was clear that Title IX applied to sports, there has been opposition to Title IX's intervention into the market-driven model of sports. So if you think way back to the Tower Amendment, those of you Title IX aficionados will know what that means. Back in 1974, there was an amendment proposed to Title IX. It failed, but proposed by Senator John Tower that would exempt revenue-producing sports from Title IX. And the argument was if Title IX applied to revenue-producing sports, it would be devastating. It would kill the big revenue producers that make everything possible. Now that amendment failed, and it was replaced with the Javits Amendment, which required regulations that would take into account the nature of sports, but there was no exemption for revenue. And these tensions have been fought in different ways all along. Historians of the NCAA will remember that the NCAA first opposed Title IX altogether. Made the argument that Title IX would be the death of football, and that would be the death of the goose that lays the golden egg and supports all the other sports in the program. Now, the NCAA eventually came around when the NCAA took over women's sports in the 80s and then responded to a lot of pressure in the 90s and perhaps saw some gain in becoming a different sounding board on Title IX. The NCAA has, at least in recent years, been a mouthpiece, which I might underline that word if we want to talk about March Madness later, but a mouthpiece for gender equality. So anyway, these struggles about how to reconcile an educational model of sport and a civil rights law with market forces that have historically devalued women's sports and advantaged men's sports, these are age-old concerns with Title IX. That said, the issue here is new in its specifics. So let me go then to your question, which is more about what are the Title IX intersections with this specific issue. And here's where my humility has to come in, but I'll start with at least some basics that are worth reminding folks about in terms of setting the stage for how does Title IX intersect. The first point we might note is that whatever the NCAA ends up doing, the NCAA is not itself covered by Title IX. And there was a Supreme Court case, Smith versus NCAA, that was actually a homegrown Pittsburgh case that came from a student athlete, Renee Smith, from Pittsburgh School of Law, challenging an NCAA rule. And the Supreme Court settled, I would say maybe not for all time, but at least in the immediate future, settled that the NCAA, just because it is a membership organization and receives member dues and has members that receive federal funding, all of that is not enough to make the NCAA an entity that receives federal funds in the legal sense that Title IX requires. So the NCAA is probably not itself covered by Title IX. That said, its members are. And so how its member schools handle the NIL issue may well have implications for Title IX compliance by the member schools. And it is no defense to a Title IX compliance problem that a member school is following an NCAA rule. That is no defense. The other sort of foundational point we want to keep in mind is that that the market factors led to the compliance problem has not been a defense to a Title IX violation. And the clearest example of that is with private booster funds. If private booster funds have paid for an inequality rather than the school is still responsible and accountable under Title IX for the disparity that private funding created. So for example, if private booster funds paid for a great baseball stadium and that sets up a facilities violation under Title IX, it is no defense to say, well, that was private funding. Okay, and then finally, in terms of foundational principles, we should also keep in mind that it is an overall program comparison that Title IX is looking for. Title IX is a pretty unique anti-discrimination law in that it is applying in a context of sex-separate programs. And that has led to all kinds of complexity and frankly interesting stuff in this pretty unique area of law, that Title IX compliance turns on an overall program comparison between women's sports and men's sports. And the equal treatment standard looks at all kinds of program benefits and treatment. All right, so I'm getting increasingly specific, and now I'm leading up to the point where I really need that big dose of humility in asking, well, what about the NIL issue specifically? Are there Title IX consequences here? Title IX has certainly figured prominently in the debate about NIL issues, with there being no consensus at all here, but certainly critics of loosening up NIL rules contend that this is going to create a lot of pressures under Title IX, that it's going to make it more difficult for institutions to comply with Title IX, that it perhaps will drain funding from athletic programs that could otherwise be used for women's sports. On the other hand, there are many advocates of women's sports who have taken the contrary position and argue that it could be a boon to women's sports. So I would say there are two unsettled questions here that might be helpful to separate. One is whether loosening up the NIL rules might lead to a Title IX compliance problem if at a particular institution, the NIL deals are sweeter for male athletes than female athletes. Is that institution then going to find itself in a Title IX compliance problem? And then the second question is more the policy one of the consequences for women's sports. Is this going to be good for women's sports? Is this going to be bad for women's sports? I would say there is uncertainty about both of those questions. And I'm probably going on a little too long here, so let me try to tie it up. So on the first question, I would say there's no consensus. Is there a potential for a Title IX violation? This is a particularly muddled area because it is likely that many of these NIL income payments would come from third parties, not directly from schools. But that does not necessarily mean that schools would be entirely off the hook in terms of Title IX if there were inequalities resulting from those deals. For one thing, schools may still be involved in the NIL relationships or in the NIL contracts, whether it is from procuring them or reviewing them or overseeing them. What will be the extent of the school's involvement? That may have something to do with how Title IX intersects here. And then even though the payments, let's assume, may be coming from third parties, that doesn't necessarily mean that schools are off the hook from any resulting inequalities. So again, there's the booster analogy that there is long-standing support for inequalities that stem from private funding not necessarily voiding a Title IX compliance issue. And there may be tie-ins from those inequalities to aspects of the education program, such as recruiting, or even effects on interest and participation opportunities, if there are disparities there. So it is unsettled. There is a very interesting article just earlier this year from a law professor at Northern Kentucky University that I would recommend, by Tan Boston in the Stanford Journal of Civil Liberties, making an argument that even private funding through NIL agreements, if there are disparities there, can create a Title IX violation by member schools that allow those. Now, I would say at this point that is not the majority view, but it is a view. This is uncharted territory in some respects. So the contrary view would be that Title IX does not apply to third-party compensation, and would make the argument that it is unlike booster funding, which supports benefits to the athletic program more directly, whereas NIL payments might be untethered to athletic support, and that they might be more severable from disparities in the program. And then apart from that controversy, there's the question of whether, even if schools aren't directly subject to suit for such disparities, what if there's a disparate impact? And there are school practices that allow that disparate impact. So the likely, legal position that we're in is that schools probably can't be subject to private suit for damages for disparate impact. But OCR may well be able to enforce the disparate impact regulations against schools. So there's a concern about disparate impact. Okay. Well, so far I've been assuming there's going to be a disparate impact. Will there be? Do we know how this all will play out for male and female athletes? And I would say I certainly don't know. Historically, we've seen that the market pressures tend to devalue women athletes and women's sports and privilege men's sports and male athletes. But there have been a lot of changes in the market that I think make that difficult to predict. And there's a student note that's very interesting by Sarah Trainer in the Wake Forest Business IP Law Journal that argues, I think in a rather interesting way, that women's sports actually have a lot to gain from opening up NILs, and makes the point similar to the opening speech that there are new ways of monetizing things, like being a social media influencer. Now, I barely know what that is, but I know enough to know that there are a lot of young women out there who have really successfully capitalized that in a lot of different markets. And it may be that that is a way of monetizing women's athleticism that opens up new possibilities for women that frankly haven't been there in the pro market. And maybe that will be a driver of growth for women's sports. So I think the policy questions in particular are very difficult to answer. So I will stop there.
Well, wonderful. Thank you. I will say against that backdrop of uncertainty, then I'll ask this of Professor McCann. What have been some of the legal or the avenues for legal challenges for the current NCAA NIL restrictions? If you want to walk us through some of the legal landscape.
Sure. So I think the one starting point would be the Ed O'Bannon case, which we talked about earlier, where Ed O'Bannon was retired from the NBA. He had previously been a star at UCLA, and he was living in a suburb of Las Vegas with his family, and a buddy of his told him, "Hey, Ed, you're in this video game." And Ed said, "What do you mean I'm in a video game? Why would I be in a video game?" And his friend said, "Well, my son is playing this Xbox game, and they have classic teams on it. And you're actually the best player in the game. So you got to come and check it out. You'll love it. You're the star." So he went over to his friend's house, and Ed was the star of the game. And it was Ed's appearance. It was a 6'9" African-American male who was had the same skill set, same jersey number, pretty good appearance in terms. I mean, obviously this is back in 2009, so the graphics weren't like they are today, but it was obviously him. And he thought that's interesting. It's kind of cool that I'm in a video game, but nobody ever said to me, "You're in a video game." And he thought while he did very well financially playing basketball, a lot of his teammates were in that game and they never made any money playing basketball. And that sparked eventually an antitrust litigation against the NCAA and Electronic Arts, the publisher of the game. And the case had a couple of basic claims. One was the antitrust claim, which is the NCAA and its member schools have conspired to limit what college athletes can get through the use of their identity in commercial products, in this context, video games, and they set the price at $0 because they weren't paid anything. And there was also a right of publicity claim that under California law, the athlete's right of publicity was misappropriated by being in these games and not ever having consent to be in those games. To make a long story short, Electronic Arts settled with O'Bannon, which became a class action, and the players received in the ballpark of $2,000 to $7,000, depending upon how many games they were in, how featured their teams were, and other criteria. So the players that were on these classic rosters were able to get some money, and they didn't become rich through it, but they got something which reflected the use of who they are in a commercial product. And it was interesting that Electronic Arts settled, because I think it goes to the idea that Electronic Arts wasn't protecting the system of amateurism, right? Electronic Arts makes video games. They would probably rather have the players' names in the games so that they can make the most realistic games possible. And Electronic Arts recently announced that they're coming back with college sports games, I think in 2023, so not anytime soon. But during pretrial discovery, it was revealed that the players' names were included and then removed before publication, which for all of you that are studying law, pretrial discovery can be pretty damaging in a case, depending upon what's revealed in internal documents. And as luck would have it, the announcer could say in the game the player's name. I wonder why, right? So there are all of these aspects about the game where it looks like it was clearly the player, but they tried to finagle it so the player's specific identity wasn't used. But it went to court and the NCAA lost at the district court level and also at the Ninth Circuit. O'Bannon showed that it was an antitrust violation to take players' identities and deny them a chance of receiving compensation for them. There have been other connected cases to that, but that's sort of the big one that has come up. There have also been cases involving video games, but it's a fertile area of law and it's an unresolved area of law. And I think what we've seen with these NIL statutes is that lawmakers have said, we can keep going to court, but wouldn't it be better that we just come up with a law that says players can take advantage of these rights? And you could ask, why do we even need an NIL statute? One could argue that the right of publicity already covers this, that the idea that an NIL statute is necessary, I know has struck some as a debatable point. But those are sort of the key points in terms of the law. I think how the statutes play out over the next month, whether they wind up in court before July 1, whether the NCAA comes up with a federal rule. And of course, that doesn't address some of the great comments that the panelists just raised, particularly with respect to Title IX. That's going to take time to figure out. I don't think we know the answers. So for those of us who write about sports law, it's really an interesting time. But I would say for schools, it's also a stressful time because of this uncertainty. You know, we don't know what's going to happen, then there's a good chance that a lot of folks don't. And I think for schools, just as a practical point, having advice on how to navigate through this would be helpful so that they don't make mistakes that later on surface. And so that they don't think they have the right answer. I think we just discussed, there's a lot of uncertainty about these issues.
Well, excellent. So with that, why don't we move on to our next topic, which we're going to talk in more detail about the Alston case. And I was very relieved when I woke up this morning to see that the Supreme Court did not hand down a decision in Alston today, because that was one of my biggest fears at the current moment. So we can still wildly speculate about what's going to happen possibly tomorrow or at least sometime within the next month, we shall know the future a little bit, although it sounds like never for certain. So now looking at sort of Alston, we will have a handout that will be linked in the chat that Stephanie is posting now for those in attendance who want a little bit of background. But I do want to start with Professor Feldman. If you could tell us a little bit about what Alston is about and what are some of the legal arguments made, in particular because it is essentially antitrust. So perhaps you can give us, again, a semester worth of content in a few minutes here.
Sure, I will do my best. I do want to just comment on a couple of areas that Professor Brake mentioned, because I think she covered such a lot of ground really well. And there were 2 points that jumped out at me that I just want to touch on. One is the idea that Title IX might destroy college sports or might destroy college football. And you hear that argument a lot. And I want to preface this remark by saying, I really like college sports. I work at a university. I love 99% of what the NCAA does and what college sports are about. And I think there are a lot of really good, smart people working in the NCAA and certainly athletic institutions. So this is not meant to be any sort of disrespect for the institution itself. There are just, I think most people would agree, some problems with the current system, whether those are structural or systemic. And we're just trying to figure out a way to make the system fairer, better for college athletes. I do consulting with the Knight Commission. That's a lot of what the Knight Commission tries to do. And I know they're one of the co-sponsors of this event. But I do want to say that the argument that Title IX might destroy college sports, it's almost like a Mad Lib argument that pro and college sports use, where it's fill in the blank area of law will destroy sports. So it's either antitrust law will destroy sports if we apply it, labor law will, the ADA will, tort law will, workplace drug testing laws. There's this whole series of arguments that leagues have made that said we need special treatment because we're different and the law was not designed to apply to sports. And in many cases, they were right. But you could say that about most industries. A lot of these laws were not designed to apply to technology industries, but we're applying old laws to new industries. And that's a challenge in lots of industries and doesn't mean we should necessarily exempt it, but it may mean that it's complicated to apply Title IX or antitrust law to college sports. Right? I think we can all agree on that. The other point is just when Title IX gets raised as well, can we allow NIL rights? Isn't that going to implicate Title IX? And some people, they say, oh yeah, it might, so we can't do it. And my answer to that is always, well, it's going to implicate a lot of areas of law. It's going to implicate intellectual property law. We have to figure out how athletes can use their trademarks of the schools, what their right of publicity allows them to do. We don't say it's going to implicate IP law, therefore we can't do it. We have to figure out how we comply with the federal law and the federal regulations that are in place, but it shouldn't be an obstacle. And so as Professor Brake said, I see Title IX as an opportunity here, not an obstacle, and ideally an opportunity to provide more benefits for women in sports. So I'll just wanted to add those 2 things there, and then I'll dock my time from my Alston discussion with those comments, and I'll be even more succinct with the Alston comments.
You are absolutely fine on time, and I appreciate that that additional insight.
So, well, thank you. On Alston, it's really the next step in the litigation that Professor McCann talked about. While O'Bannon was still pending in the Ninth Circuit, the Alston case was filed, and the Alston case sought even broader relief than the plaintiffs in O'Bannon did. As Professor McCann mentioned, O'Bannon was primarily focused on name, image, and likeness rights in video games and television broadcasts and cost of attendance. The Alston case said there should be no limits on what schools provide to athletes, or at least the NCAA should not be able to, as a national governing body, agree on those limits. The schools can decide they don't want to pay the athletes. The conferences maybe can decide that they don't want to pay the athletes because they don't have market power. They only have the ability to control the prices or the salaries. But the NCAA itself shouldn't be able to do it. And the NCAA's first move in that case was to say, well, these issues have already been decided, and they've been decided in this court because Alston was assigned to Judge Wilkin, the same judge who decided O'Bannon, and then it was appealed to Ninth Circuit, the same circuit that also decided O'Bannon. And in O'Bannon, the discussion was really, look, college sports has changed a lot. The revenues have exploded. There does seem to be this growing disparity and maybe unfairness, but the definition of amateurism in college sports means that they are not paid beyond their educational expenses. So the NCAA can limit expenses that are untethered to education. And the NCAA said, really what the Alston plaintiffs are asking for is compensation untethered to education. And so the issue ended up being narrowed, and it's now narrowed in front of the Supreme Court, where the Ninth Circuit said, we're bound by O'Bannon. That was our own court just a couple of years ago. But part of what the plaintiffs argued for is, even if you're not going to allow payment unrelated to education, there are currently restrictions on payments related to education that are unnecessary. Even if we accept, for sake of this case and sake of argument, that the NCAA does have a legitimate goal in restricting these payments unrelated to education, there are two buckets of payments related to education that have limits that are unnecessary. One, what the court and what the plaintiffs called sort of in-kind benefits related to education. So those would be science equipment, musical instruments, other things like that that are not cash, but they clearly have a value. And the plaintiffs argued, and the court agreed, no one's going to think that a college athlete is a professional because they've received a piece of science equipment. That's not going to destroy the line between college and pro. And then for the cash-related benefits, there are sort of academic awards, academic incentives. There's also sort of in the middle there, paid internships, post-eligibility paid internships, post-eligibility graduate scholarships. And the Ninth Circuit there said, well, when it becomes cash, even if related to education, there might be concerns if it's unlimited cash, even if related to education, that might blur the line between college and pro. So the NCAA can put a limit on the cash payments related to education, but that limit can't be lower than $5,900, and it would take me 45 minutes to explain why the limit is for $5,900. But there is the ability of the schools broadly to restrict the cash-related education payments that are cash, but it can't be below this particular number. And the Ninth Circuit said, you can still have amateurism. You can still have the distinction between pro and college and allow these additional benefits. And the NCAA's response to that, and they're the ones who filed the petition for cert with the Supreme Court, is that that is really not the role of an antitrust court. You're not supposed to come in and micromanage and second guess whether a piece of an instrument is permitted or not permitted. That's for the governing body to decide. And the Supreme Court in the Board of Regents case in 1984 said that essentially college sports are different and amateurism is a legitimate goal, and the NCAA should be given ample latitude in order to maintain the revered tradition of amateurism. And the question in a lot of ways that the current court is facing is, do they still want to, do they recognize this tradition of amateurism as revered, or have times changed enough that it's no longer a legitimate argument? And if it is a legitimate argument, does it still mean that the NCAA can decide all of the rules, or is a court allowed to come in and say, there's really no justification for having a blanket restriction on these non-cash education-related benefits, or this maybe additional restriction on cash-related education benefits? So that's sort of where we are, and I think it's sort of anyone's guess about how the case might come out. If you listen to the arguments, there was we always say that sports is one of the great unifiers, and I think we saw that in the Supreme Court, that it unified left and right, and the justices on the one hand were, I think, generally appalled by the fact that there are billions of dollars being generated, but very little of it is going to the college athletes. And then on the other hand, they were also, I think, generally concerned that if they allowed additional payments to college athletes under antitrust law, would that destroy this thing called college sports that we love? And in all the arguments, there was very little discussion of antitrust law. It was mostly, this doesn't seem fair, but we're worried about destroying college sports. And then the antitrust lawyers are saying, well, wait a minute, shouldn't we also be talking about how antitrust law might apply here? But that goes back to the point I was making earlier. where the NCAA and pro sports leagues have argued for a very long time, antitrust law doesn't really neatly apply to college sports. This is an interdependent venture where you have competitors that are cooperating to produce this product. And we're not talking about a bunch of oil companies coming together to raise prices to consumers. We're talking about colleges coming together to restrict the compensation to college athletes. How does that fit in with antitrust law? And I think that's going to be potentially the billion-dollar question. But I have no idea how the case is going to come out. But as some of my friends say, I'll tell you once the case is decided how it's come out. But I don't really have a prediction until then.
It's probably wise. I'm usually wrong in my predictions. So how about implications of Alston and possible implications? Why don't we begin with Professor Brake and implications on gender equity?
Well, I also don't know how the case is going to come out. And in general, I'm terrible at reading the court's tea leaves. It did seem like the questioning was tough on the NCAA, but you really never know. So I think, there are also a lot of open issues in terms of the implications for Title IX. And I think here we're really talking about what does the NCAA, if the NCAA loses, and so if there are changes then that, whatever the result exactly is in terms of the remedy, if there are going to be loosened up restrictions on what, you could say pay for play, or on an expanding benefits, on raising the limits on what counts as an educational benefit, I think then, as our newest justice asked, it is important to think about the implications for Title IX. What will be the impact for Title IX? And once again, Title IX is being used perhaps strategically by entities that aren't always on the bandwagon about Title IX. The big time athletic programs, made a big argument in some of the briefs about the pressures it would place on them under Title IX if the NCAA lost, if they had to expand payments to athletes, that that Title IX would require them to do that for women, and that would make compliance very difficult. That would break the bank. And in support of that, there was a poll that was reported recently, I think it was ESPN, it might have been Sports Illustrated, that most athletic directors polled, a significant majority, substantial majority of athletic directors at the big programs polled said that it would make Title IX compliance more difficult. And my response to that is, that it's more difficult. That's a very familiar argument, isn't it? To sort of villainize Title IX for creating these pressures that in fact the institutions themselves have created by the structure of their programs. And all of a sudden, when it comes to expanding those benefits to women, it's a break the bank situation. So I think it is the sort of classic argument in some ways of leave revenue sports alone or treat them as exceptional, and looking for ways to get out from under Title IX or use Title IX to push back on changes. In terms of the actual consequence of Title IX, if in fact schools did pay or provide greater benefits to athletes, I think that then is quite clear that whatever more generous benefits, whether they are tethered to education or not, whatever more generous benefits institutions are providing to male athletes, they have to do so in an equitable way for women under compliance under Title IX. Whether we call it athletic aid, which has to be proportionate to participation. If the pot of athletic aid is expanded, it must be done in an equitable way under Title IX, in a way that is proportionate to women's athletic participation. Or if we call it benefits under the equal treatment standard, there's still the overall program comparison that's going to be requiring that to be provided in an equitable way in terms of the overall women's program versus the overall men's program. And it's no defense or reason for an exception to argue that that men are more entitled to the better treatment if they are bringing in revenue. And that is one thing that bothers me about the tenor that this debate in general on the issue often takes, that the case about exploitation is often made focusing on how schools are making profit off of athletes who aren't making profit. But I think that there is much more to the exploitation case than just the revenue. And we have to keep in mind that schools benefit in lots of ways besides broadcast revenue or gate receipts from their sports programs. They benefit in enrollment, in applications, in donations. You know, they benefit in lots of ways that are very much benefiting from the women's program as well as the men's program. And the exploitation from the athlete perspective is not just about someone else making money off the athlete. And let's keep in mind that most programs don't still make net revenue. It really is a tiny, if you look at the entire universe of college athletics, it's a small minority of programs that really make net revenue. But the exploitation case in terms of athletes is not just about revenue being made off of the athlete, it's also about the opportunity cost for the athlete, and the costs to education and compensating those costs. And that is very much a case for equity for women athletes as well. There was a survey that was reported recently of women basketball players and showed that women basketball players spent comparable time on their sports as male basketball players and football players, and felt similar in terms of the compromises that had to be made in terms of taking courses and studying and reaching their academic potential. And then there are the injuries. You know, part of the exploitation case is about the injuries and the short athletic career. That too applies to women. So in some ways, the all the focus on exploitation in terms of revenue made is, privileging the one piece that tends to make the male athletes look more entitled to the privileges and benefits than women athletes. And so I think we do need to be careful in the discourse of how the case for exploitation gets made. But all that said, in terms of the Title IX consequences, Title IX requires, if the pie is expanding for male athletes, that it be done in an equitable way for women athletes too, whether we're calling it athletic aid or whether we're calling it treatment and benefits. And so I really liked what Professor Feldman said a moment ago about Title IX being an opportunity, not a reason not to do it, not a reason not to take a hard look at the fairness issues. And because I do think that there's a lot there to the case for exploitation that needs to be addressed. But Title IX is an opportunity to make sure that we do that in a way that opens up opportunities and addresses exploitation for women athletes as well as male athletes. And so, I think it's going to be very important to figure out the Title IX compliance piece in the aftermath of Alston, especially if the NCAA does lose.
Well, I think that's a great transition to our next sort of implications. And I will ask Professor McCann, what are the implications for administrators?
Well, I think there are a whole bunch, and it does depend on what happens in terms of this case. But if the NCAA loses in some form or another, there will be rule changes that will be needed that will have to be implemented by the individual member schools and also conferences. So that would be one immediate hurdle. Similarly, NIL statutes are going to put schools in a position where they can't comply with NCAA rules and also comply with state law. So they're going to have to pick, presumably following the law is better than following a membership rule. But that creates an opportunity for breaching a membership contract. So it's not as if it's a cause. Some have said, well, they're just going to follow state law. Well, when you sign a contract, that's also the law, right? So you have a contractual duty to adhere to your membership obligations. So they're really in a spot, and whether we should feel sorry for them, that can be debated, but they're in a spot where they're going to have to follow one thing or the other. And I think it's going to be very interesting for compliance folks to navigate through that. And I know that the next panel has a number of academic and athletic administrators that will likely be able to shed some light on how they're going to approach that. But the administrative hurdles are going to be pretty considerable unless there's some type of best practices, unless there's some type of sort of ground rules as to how to address these issues. In a case, in a court of the O'Bannon case, for instance, there was time, I think about a year, where an implementation period was allowed to avoid the sudden change. Well, these NIL statutes start on July 1, and there's no, well, you get 3 months, you get 6 months. That's not in the law. So if the NCAA loses the Alston case, perhaps there'll be some type of grace period for schools and the NCAA to adjust to the changes, but the NIL statutes don't contemplate that. And the changes are coming on that date. So there will be hurdles for athletic administrators, for compliance folks. And I also think the hurdle is going to be, they don't know what to do. And it's not their fault. It's because of all the reasons we've been talking about, where there's uncertainty as to how to apply certain rules. And maybe we'll get some guidance from the Supreme Court, but the Supreme Court is going to be focused on addressing the legal issues, not necessarily the implementation or compliance issues that are going to be really important. So it's going to be fun times ahead for a lot of athletic departments, but also opportunities, to use the word that was just described by two of the other panelists, where these will be opportunities to be creative, and for compliance folks, it's an opportunity to think outside the box, because the box right now is hard to look into because it's being concealed by uncertainty about the law. So this could be a time for some creative thinking, and maybe changing some things the way they've been done for a long time in a way that addresses some of the concerns that have been talked about on this panel.
So with that, we have one more stakeholder I want to ask about, and this will be directed towards Professor Penrose. Let's talk about the student athletes. So what are some of the practical concerns in the possible wake of Alston for college athletes, and whether this opens up any new avenues for corruption, for example?
Well, I think Professor McCann just hit on a big point, as did all of these panelists, and I'm going to try and weave my comments into that. I mean, change is coming. It's coming. The question is, what's the source of that change? Will the United States Supreme Court cause this first disruption? Will it be these name, image, and likeness statutes at the state level? Is it going to be the free market, right? What is the change? And then, as Professor McCann said, July 1, we're going to be flying a plane as we're building it simultaneously, right? So there's this whole situation is fraught with risk. Right now, what do college athletes get? They get recognition. They get to play at the highest level in our country. They get the notoriety. The influencers that they are at this point come from their social media presence, but they're not able to monetize that. So this question becomes, is it time to monetize those elements of college athletics that have value, monetary value, the individual's value? And I think, that's this question. Is the value of college athletics playing for the University of Notre Dame? Is it suiting up for Oklahoma? Is that the value? Or do you get something when you take off that jersey and you walk down the street and you're the athlete, that person? And I think we're moving in that direction. I mean, all signs certainly demonstrate that. But then that raises what Professor Brake discussed, which is the exploitation. That where there is money, there will be exploitation, right? So that's what's next. And so the question becomes, what's the source of exploitation? Well, it's probably going to shift. We're going to move from those that see the universities benefiting unfairly. There's a group of people that see that as an unfair benefit to the universities and at the very different levels. But now what? Who's going to be there to protect these athletes, right? As Professor McCann said, well, compliance is going to have to be dealing with this, all of the individuals. But don't forget about the coaches, all right? Coaches, whether you think they're overpaid or not overpaid, Coaches have their entire career depends on the judgments and performance of 18 to 22-year-olds, right? That's a high-risk profession. And they're now going to also probably be getting questions from these individuals that they build relationships with. A good coach has healthy relationships with his or her players. And that relationship, what is going to be the risk for a coach if he or she advises someone about whether they should take a particular deal? I think this put coaches in a very difficult space, because a lot of these state statutes also say athletes cannot get name, image, and likeness benefits from team events. So what about those instances where the women's gymnastics team is supposed to be signing autographs at the men's basketball game, but they could actually be earning money for signing autographs outside of the institution, right? Now you're going to put possibly coach and player at conflict. There are about 150 name, image, and likeness platforms that are operational at this point, and that's before July 1. Like Professor McCann said, we're May 25. Can you imagine what's going to happen on July 1st? And will the marketplace exploit someone? In the opening comments, Professor McCann said, you know, these kids should be able to host a camp in their hometown and make $500. Well, $500 seems like a lot to a college athlete. So will the marketplace be exploiting them? Some of these name, image, and likeness statutes prohibit agents. Okay, an agent could be a source of corruption because they're going to come in and take advantage of someone at a time. For some of these athletes, their highest earning potential is going to be during their college years. It just is. Their value, their notoriety, and they may not have the same success when they go to the next level. So this patchwork of legislation becomes a problem. Who is going to protect the athletes? The institutions are going to have to give, under some of these statutes, education about taxation, education about contracts. But again, you're trying to give someone a baseline of information. You can't teach someone in 3 to 5 hour seminars the risks they're facing and the exploitation that may come their way when they, at the 18 to 20-year-old mind, is seeing $5,000 when their value may be $50,000, right? This I think is going to be a very serious issue. And my greatest concern is what is going to be this, not the source of change, the source of corruption. And what are we going to do from the perspective of universities that have these athletes in attendance to protect them from any potential exploitation? I mean, we already know that there's going to be instances where, and I think this was one of the questions that was put down below, what happens when your school is a Nike school, but Under Armour wants to sign you to a contract? Some of these state legislations speak to that. Some of these do not speak to that. This is the problem with the patchwork approach. You know, at some point, I think we're going to need a universal solution, because I think it's going to help eliminate some of the exploitation that I worry is coming as soon as these changes take place.
Yeah, and perhaps we can actually explore this audience question more. So Stephanie, I'll invite you to unmute, and if you want to pose any audience questions for us at this point before we transition to talk in more depth about the legislative landscape.
Professor McPeak, can I just jump in with just a comment on that, the corruption idea? So yeah, I agree with everything Professor Penrose said. I would only add, though, that the current system is not working very well. And there are so many challenges in terms of the increased commercialization and I think the dysfunction of governance in the collegiate model. And I think priorities and incentives are out of whack. And we've sort of lost the mission in a little bit and why we have college sports and what we're trying to achieve. And in all of that, athletes are being abused and exploited, and there is corruption, and we don't know about a lot of it because it's mostly under the table. And so if we were in a situation where we were corruption free and had a good system, you say, well, now we're going to make this big change and all of a sudden we're going to have corruption, I'd say, well, wait a minute, maybe we should think twice about it. But there is already so much of this going on, and there are already so many problems. And the one thing that's not happening is the college athletes are not able to benefit from it, or at least not able to benefit it beyond their educational expenses. So I completely agree with Professor Penrose that there are going to be lots of additional opportunities for corruption, whether it's dealing with the agents, dealing with the third parties, dealing with the market in general, and a lot's going to have to be done around it. But at least while that is happening, the athletes are getting greater benefits. Right? So in my mind, the greater benefits outweigh the potential corruption or abuse of the system. Doesn't mean we don't have to address the abuse and corruption, but there's at least a positive that goes along with it.
Can I jump in as well? I mean,
Yeah,
it's
please.
interesting with this issue where the marketplace is changing around college sports too. Look at the NBA G League, right? Where players can now make $500,000 a year. I mean, the NBA is going at the same talent pool that college sports has recruited. And I would think that just sports in general are going to become a lot more professionalized at a youth level than they've already been. I don't know how that shakes out in terms of corruption. I agree with both Professors Feldman and Penrose that the corruption will happen, and corruption is already going on. But what I think we will see is a more professionalized system, but not necessarily in a way that the NCAA wants or that colleges want. And that might start a lot earlier than when they go to college. It might be more akin to the European model, where players go to camp. So in fact, there's now a basketball league starting up for high school basketball, for as high school basketball players, a pro league. So it's just interesting that the college sports is operating in a larger context, and in a way it reflects the fact that there hasn't been enough change in college sports.
Yeah, so with that, let's talk about the question from the audience, really dealing more with sort of legal challenge for students who are athletes. So Stephanie, if you want to walk us through that.
Yeah, so on the face of that corruption facing student athletes, corruption that has been in the past and potential corruption in the future, a question from the audience is there a potential legal challenge for students who are athletes seeking relief from some of the conditions of the different state NIL laws, such as those that restrain those student athletes from seeking compensation from corporations that have existing agreements to sponsor university athletics, such as Pepsi or Nike?
I'll jump in first. I mean, I think this is part of the NCAA's argument in Alston, is they have made an attempt to loosen the restrictions on athlete compensation, and NIL being an example. And when they proposed, they had each division introduce NIL legislation that would essentially allow college athletes to be compensated by third parties for name, image, and likeness, with other parameters around it. But soon after, there was a lawsuit filed saying that these restrictions are illegal under antitrust law, because although you're allowing NIL compensation, you're restricting the type of NIL compensation you can give. And in the Alston case itself, the plaintiffs had argued they are giving, as Professor Penrose talked about earlier, they're already giving benefits to college athletes beyond just their educational expenses. And they've already opened up, they've given now unlimited food, all sorts of things that they didn't give in the past because they claimed it would violate amateurism and destroy college sports. They give full cost of attendance, things that they argued in the past would destroy college sports, would violate amateurism. And the plaintiff said, look, there is no real amateurism line. The NCAA, it's just what the NCAA says it is. And their restrictions are therefore unreasonable trade and illegal under antitrust law. And the NCAA said, well, wait a minute. We're getting sued when we have the restrictions, and then when we loosen the restrictions, we're getting sued, because if we loosen them enough, there's really nothing we can do. No matter what we do, we're going to get sued, unless we just allow anybody to do anything, or unless we get Congress to step in and give us an antitrust exemption to say we recognize this is sort of an untenable situation. But I think the question is a perfect example of that from the NCAA's perspective. If the laws allow certain NIL payments, but not others, does that potentially raise a legal issue? Put aside whether it's if it's the state law, let's assume it's the NCAA that agrees on that. If the NCAA says you can't do a marijuana deal or an alcohol sponsor, can the athlete sue and claim that's illegal under antitrust law? Yeah, I mean, they can bring the suit and say this is an agreement among all the schools that's preventing athletes from doing something they'd be able to do in the free market. The NCAA would have a defense to that. But again, I think that's why the NCAA is sort of, I don't want to say desperately, but fervently seeking help from Congress to, again, say antitrust law should just not apply to us the way it's applying to all these other industries, because if we allow schools to compete on this basis, it's going to bring us all down. So I do think it's unless, again, it's a total free market or there's an exemption, we're going to continue to see these antitrust suits. But I will say I'd much rather be in the position of defending looser restrictions than these blanket restrictions. I'd be much more comfortable if I were the NCAA say, look, we opened it up to NIL, but there's got to be some limit on it, right? For example, fair market value, or whether it's a legitimate transaction. I think most people would say if somebody's getting $1 million for one autograph, that is probably not a legitimate NIL deal and shouldn't be permitted. And the athletes might argue, well, you're restraining my trade. They were willing to pay that to me, but they weren't paying it to you as an NIL payment. They were paying you for something else, and that something else would violate the NCAA's sort of core amateurism rules. So I do think it puts the NCAA in a difficult position, like it puts the NFL and all other sports entities in difficult position when all of their rules require agreements among their competitors. One solution to that could be just make agreements within your conference. If you do it within the conference, then it likely would not violate antitrust law. Because if the Big Ten doesn't allow those NIL payments, the Pac-12 might, or the ACC might. And athletes would always have an opportunity to have a substitute. They can choose something else, which would prevent that restriction from really harming them, because then they just have a choice of where they want to go.
Look, if I can jump in, I mean, I really think that this issue of paternalism is a problem, right? Because we need someone to have oversight. And the question is, who is best suited for that oversight? Because there is exploitation and there is a lost opportunity for students. Who best provides that solution? Nearly every one of these state laws has some form of paternalism. You can't represent alcohol. You can't represent tobacco. You can't represent casinos. So it isn't a free marketplace for these individuals. They are not given unrestricted opportunity to get the value that I hear a clamoring for is their right. So either they have this free market right, or we're going to continue to regulate them and we're going to shift that regulation to a different entity. So unless I'm mistaken, the federal regulations that are being considered, every single one of them right now creates like an oversight commission, right? So now we're going to add a level of federal bureaucracy to figure out whether these students are getting their proper opportunities or whether they're continuing to be exploited. And that's on top of the NCAA issues, that's on top of the Title IX issues. And so at some point, I'm starting to grow concerned that if the issue is the fear that the students aren't getting their free market value, let's give them their free market value. But if we put all these restrictions on that, how have we actually remedied what we see as the concern? And then that falls back into, as Professor Feldman was saying, this key of amateurism. What is amateurism in the United States? I mean, in Texas, we actually have drafts for Pee Wee football. So at age 10, you're the #1 draft in your football league, right? So this notoriety, this value we're placing on athletics starts at the youngest levels now. And so someone is building a reputation, and if they could monetize that right, would that benefit be worth whatever the sacrifice is? I certainly don't have the answers to that. But I do worry about just placing it in the federal government's hands and then creating all these new commissions with a different type of bureaucracy because we don't like what the NCAA has done.
So with the sort of alluding to what the proposed federal legislation and what some of the actually enacted or proposed state legislation would do and its implications, why don't we go to Professor Feldman and get sort of a landscape of what are some of the legislative reforms that are out there?
So just very quickly, there are now 16 states, at least as of 2 hours ago, 16 states that had passed NIL legislation that, although there are variations, they generally allow college athletes to be paid for their name, image, and likeness by third parties and to use a professional third party to represent them in the transaction. There is, as I understand it, Texas, their bill that's been introduced would allow schools to prevent athletes from using agents. That's more of an outlier. Most of the legislation explicitly provides the right to use some professional representation. 6 of those laws that have passed, of the 16, would take effect July 1, 2021. And there are 12, as I understand it, 12 laws that are bills that are very close to being signed into law. And a number of those would also have July 1 effective dates, if not sooner. So we may have, within a matter of weeks, 28 state laws that have been passed that give college athletes more or less the same rights, but there are some differences in terms of conflicting sponsors, as we've talked about. Again, Texas different in terms of agent representation and some other differences in there. We then have at the federal level, 9 bills have been introduced in the last 2.5 years, 3 in the most recent year, that would allow college athletes, again, to receive compensation for name, image, and likeness from third parties. All of the legislation tries to draw a line between third parties compensating the athletes and the institutions compensating the athletes. And that's been one of the key principles of the Knight Commission, is we don't want the institutions paying the athletes and we don't want them involved in paying the athletes, because it's very difficult to draw the line between pay for play and NIL if the institutions are involved. At the federal level, just broadly say that there's a distinction between the NIL bills and the NIL plus bills. The NIL bills look like the state laws that allow NIL compensation. The NIL plus are more along the lines of the College Athlete Bill of Rights that Booker and Blumenthal introduced last year, that Senator Moran recently introduced, that provide not only NIL compensation, but also greater healthcare, greater insurance rights, lifetime scholarships. The Booker Blumenthal one also provide revenue sharing, a share of the revenue that the schools certain schools generate through the athletic department. They have to share with athletes. I don't know that that's going to appear in future legislation, but that's sort of a sense of what the NIL plus looks like. And then, of course, the NCAA itself has now said that they plan on voting on their NIL legislation at the end of June. We'll see if that happens. But so we have Alston that could be decided any day now, state laws, federal legislation, and the NCAA itself. And then there's the possibility, as Professor McCann said, that we have this Wild West come July 1 when these state laws take effect. It's still possible the NCAA may sue the states and argue that the state laws violate the Dormant Commerce Clause and they interfere with the NCAA's ability to have uniform governance in their interstate sporting operations. So we'll see. I don't know that the NCAA wants to be in a position where they're suing, for example, the state of Florida because they are trying to give their athletes more rights. That's maybe not the best look when you're going to Congress asking for help. But in the legislation or the bills at the congressional level, the last piece I'll mention, as I mentioned earlier, is the NCAA is asking Congress for help, both to preempt the state laws so they can have a uniform policy. And I think most people agree that uniformity is important in this area, and also asking for some type of antitrust exemption to fend off the next Alston case or the next lawsuit that will be filed challenging restrictions on college athlete compensation. So that's the lay of the land as of, again, 11 a.m. Central Time today.
Not at all a hot topic, right? Nothing new happening here. So with that sort of landscape, how about Professor Penrose, if you want to talk a little bit about what you think the risks are in adopting some of these, particularly things like what these types of NIL rights for individuals would do to team chemistry, student welfare, time management, and those types of issues.
Sure, and I think Professor McCann suggested this earlier, maybe in the opening statements, that NIL rights are not going to probably apply, that you have them, but they may not actually benefit that many students, right? We're probably talking between 1% to 3% of every student athlete at a particular institution. Probably your high profile football players, men's basketball, women's basketball, perhaps women's gymnastics. It's hard to really know, right? But you don't hear a lot about fencing. You don't hear a lot about lacrosse or field hockey. And so the risk really is, how does the ability to have your college quarterback spend his weekends signing autographs and making money impact team chemistry? Well, I'm sure that's part of the NCAA's position, is this notion of amateurism and team chemistry. But it returns me to the point where I do think the coaches, it's not just the compliance officers, I think coaches are going to have to grapple with a lot of things that in the past they haven't. Right now, they structure their student athletes schedule pretty rigorously, right? Team meetings, team study hall. When there are autograph sessions, they tend to be a group of athletes and they rotate, or the entire team stays after a particular competition. And so there may be some resentment that builds. You may see some problems in team chemistry, because once this becomes something where a person realizes, I can stay here and sign autographs with the team, or I can go down to the Ford dealership and benefit financially from it, there's a tension there. I don't know that ultimately that's a negative thing, because we already live in a world where some athletes get more attention than others. Some are more easily able to influence on social media than others. But I just think, and I don't recall who said it, I mean, chaos is coming, right? It's not just change, it's the chaos or the disruption. I think Professor McCann said it's disruption, and that may not necessarily be a negative thing. It may lead us to a much more fair space for college athletes. And that, I think, ultimately is the goal. I would say, whether it's in the state legislatures, at the federal legislature, the goal is to give these student athletes their opportunities that they're not receiving at this moment. So I think the intention is certainly there, but the best of intentions may have unintended consequences that impact both athletic teams and athletic performance.
So along those sort of unintended consequences, I guess, Professor Brake, what do you think this would mean for potentially improving gender equity in particular, both the NCAA or federal reform proposals, maybe even state proposals?
Well, in terms of how to respond in terms of, legislative reform that would further protect gender equity, I would say we have a law. We have a federal law. I'm always leery about opening up Title IX to amendment. I certainly would not want to see that in the wake of this changing landscape. I do think Title IX is adequate to respond to this changing landscape. I just think we are really going to have to focus on toughening up Title IX enforcement, and we will probably need additional guidance coming out of OCR. So on the enforcement front, whenever institutions are under financial pressure, there is a risk to rolling back gains under Title IX. We saw that with the COVID cuts that a number of institutions made within the last year. Now, many of those have walked those back, whether in response to lawsuits. Of course, they say, no, it wasn't about the lawsuits when Stanford restores the teams, but the timing suggests that it came after the lawsuits, we'll just say. But a lot of those cuts look to me like a rehash of what happened in the early 1990s. Increased financial pressure on institutions, they make cuts, they cut some women's teams, and they somehow think that as long as they're cutting some men's teams, it won't create a Title IX compliance problem, because they still don't understand how the three-part test works. So if, however the world is changing, it does appear that there will be some added financial pressures. It's always tempting to scapegoat women's sports. There's then always a risk of blaming women's sports for whatever cuts come down the line to non-revenue men's sports. That is an old story at this point, but it is likely to play out. So keeping the eye on the ball of Title IX enforcement is going to be very important. In the last administration, there wasn't a whole lot of enforcement going on in this space. I hope that there will be. I believe that there will need to be moving forward. And then I think it would be helpful to have additional OCR guidance as this landscape. I probably have to wait for that guidance until we know what the landscape is. It's too soon to come out with it today for sure. But it does appear that we are on the road to opening up things like, name, image, and likeness allowances. What does that mean for Title IX? I think it would be helpful for OCR to take a clear position on that, on how institutions can avoid compliance problems if there are disparities in this new landscape of benefits, distributions that are tied to sports participation. In terms of legislative reform, again, I think the law is basically adequate. The one thing I do wonder about is if we might need legislative reform in terms of transparency. It may be that the current law is enough for that. I'm not sure. But I think it would be good to have something like, the Gender Equity Disclosure Act apply to, what are the distributions of NIL deals? What is the distribution among male and female athletes at a particular program in terms of who's benefiting? So I do think transparency is going to be important. And then it would be helpful if we had more institutional structures for internal monitoring of gender equity. What happened with the NCAA in March Madness, that's just flat out embarrassing and inexcusable to give the women's, final basketball teams the yoga mats and few handbells with the state-of-the-art men's facility. How did that happen? Because the NCAA took its eye off the ball of gender equity. Years ago, the NCAA required institutions to do gender equity audits, self-studies. And then the NCAA had a system for gender equity audits. And I'm not going to say that the NCAA did that perfectly, but at least they were looking, and they were in the practice of looking at measurements of locker room spaces and facilities and making judgments about it. And maybe through that process, they even learned some from institutions about what equity looks like. So the female basketball players who confronted those away facilities, they knew that wasn't what they were supposed to be getting. They were getting better treatment at their institutions than that. And having that kind, whether it's that, I'm not saying revive that, but something institutional needs to be done so that this kind of oversight just doesn't happen. And when there were things like gender equity audits, it often gave coaches of women's teams leverage to be able to say, hey, we need to upgrade this facility. Someone's going to be looking at this. And then not having to be in the position of just being the lone or squeaky wheel and the risks of retaliation that come with that to the coaches. So it would be helpful to look again at what institutionalized checks we have to make sure that gender equity is always being looked at, because historically, if it's not being looked at, these kinds of flat out unacceptable inequities happen.
So I think that raises an important question, which I will pose to Professor McCann then. So what exactly does all this mean for NCAA governance?
I think it means that there will be probably a greater push among conferences for autonomy, would be one part of the story, where as we're in a period of disruption, there will be conferences, and Professor Feldman noted that conferences might want to gravitate towards different sets of rules, given that they're very different, right? Conferences are structured differently. They have different revenue sources. They have different considerations at stake. It might make sense for a more decentralized system of college sports in America, where the Southeastern Conference probably has a set of goals and objectives that are different from some of the other conferences that are even near them. So I would imagine one possible change is the sort of autonomy of conferences could grow as these rules are rewritten to adapt to changes, whether it be NIL, whether it be if the NCAA loses the Alston case. I also think some conferences might now think we can do it better, that the NCAA has been very cautious, if not or slow to change, non-adaptive. And there are conferences that could come to the conclusion that they ought to have a greater say, that they can do things better. And they can bring in the perspective of students in a way that hasn't occurred. And they also have staffs that are pretty large and that have a great deal of expertise. The NCAA doesn't mean the NCAA is going to go away anytime soon, but I suspect we'll see conferences break off a little bit more than they already have done. So there's already been some breakage. And I have a feeling that's going to accelerate as some of these changes come into play.
Excellent, thank you. Why don't we open it up for audience questions? I'll invite Stephanie to unmute and select a few of the questions we've received for our panelists.
So we have 3 questions that are specific towards NIL bills that are currently pending. Do any NIL bills address international student athletes and student athlete visas that could be impacted? The question asks, because they could potentially be prevented from participating in NIL, is it likely that there could be any visa changes in that space? Second, how do the NIL statutes apply? Do they apply based on location to universities? So if student athletes are traveling for a game, can they actually participate in NIL outside of their state, or is it based on university? And then third, could NIL state laws impact private universities that potentially have higher standards of conduct across campus? So international student athletes, location of university, and finally private universities, campus-wide policies.
All right, I'll try since no one else is, everyone's silent. So I'll take a
We had our heads down trying to not make eye contact with the professor.
You can't do that on Zoom. That's the problem, right?
I was about to cold call someone. So thank you for volunteering.
Well, I'll give it a shot. So with the visa, and I think I would defer, of course, to an immigration law expert. That's certainly an area of law where there are faculty that specialize in that. But to the extent that the visa and student athletes are on a student visa, that they are out there earning income, they would have to check with the compliance folks and maybe with an immigration lawyer to make sure that taking in earnings doesn't shift their status in a way that compromises the nature of their visa. So it's an excellent question that I think an immigration lawyer would probably be best suited to discuss. In terms of the last part of it was a 3-part question, but there were 3 questions. The private schools, well, so yeah, I mean, potentially if the NIL statute says students can sign with anything or anyone, there may be some private colleges, religiously affiliated colleges, that might raise questions about that in terms of endorsement opportunities that could conflict with, if not an institution's mission, then perhaps some student conduct policies with regard to that. That's something that has to be worked out. And the second question, I believe, was the location. My understanding is that it's about the schools that are located within a state, so Florida schools, for instance. But other schools, as we talked about earlier, even in states without NIL statutes, might decide that they're just going to risk it because they don't want to lose the competitive advantage if schools in NIL states get a leg up in competition. So I'll stop there.
Yeah, I'll jump in quickly. I think I agree with Professor McKenna on all of those. And on the private school versus the public school, Representative Gonzalez's bill that he reintroduced with Representative Cleaver, which is the only bipartisan legislation that's out there so far, does have a provision in there on conflicts, which I think is a interesting way to deal with this, that if the school wants to prohibit a certain category of deals for their athletes, the school themselves can't do deals in that category either. So it really says, if it's your values, let's show it's your values, right? If you don't want to allow alcohol deals, then don't do alcohol deals yourself, which will put some schools to some interesting questions. On the location question, again, I agree with Professor McKenna. I think given that most of these state laws actually put the restriction on the school, so it's not so much that they give the athlete a right of publicity. The athlete already has the right of publicity. It's just that the schools and the NCAA are restricting them from exercising that right, that it doesn't matter where the athlete is. If it's an athlete in a Florida school, that Florida school can't restrict their ability to earn NIL. That's how I think it's intended and would work in practice. Now, jurisdiction and long arm, I mean, it could get complicated, but I think that's the general idea. And then on the immigration question, all I'll say is that I think this is one of the sort of fun parts of sports law, is that it's really 100 different areas of law, if not more, applied to the sports industry. And I think it's amazing. He gets a lot of credit. I'm not sure he gets enough credit for the articles that he puts out for now Sportico, but previously for Sports Illustrated, where Professor McCann, whatever the issue is, 3 hours after it comes out, here's some in-depth explanation of whether it's immigration law or tax law or whatever. I don't know how he does it, but it is a challenge for people who are sports lawyers or sports law professors to expect to know every answer to these really complicated issues. And I think we can do the research on it, but I would also say talk to an immigration lawyer, because it's really complicated, and a lot of these areas could be really complicated.
Thank you, Gabe. Professor Feldman.
You're welcome, Mike.
Well, I think the it's complicated conclusion is an excellent one for this particular topic. So now that we are at about 11 o'clock, we'll go ahead and break now. I wish we could do a virtual round of applause for our wonderful panelists. Thank you, Professor Brake, Professor Feldman, Professor Penrose, Professor McCann. Thank you, Stephanie, for your help moderating, and of course to our sponsors and co-sponsors. So with that, I will hand it over to Dr. Hoffman to lead us into the break.
Thank you, Professor McPeak, for moderating, and thank you, Stephanie Verdoya, for moderating the questions. And very special thanks to our panelists for your insights and perspectives on the implications of the legal and legislative changes on the horizon, even among the uncertainty that we are under in this moment.